Ready. Start. The prayer made in the present application filed under Section 11 under bracket 6 of the Arbitration and Conciliation Application Act, 1996 under bracket hereinafter referred to as the Act is for appointment of an arbitrator for resolution of dispute between the parties. Stop para. Mr. Mathur, learned senior advocate, appearing for the applicant, submitted that an agreement was signed between the applicant and respondent, Dakshinanchal Vidyut Vitran Nigam Limited, bracket open hereinafter referred to DVVNL, bracket close, on May 18, 2009 for distribution of electricity in urban areas of Agra, for which the respondent was a distribution licensee. Stop. Clause 17 of the agreement provides for resolution of disputes between the parties. Stop. Clause 17.2.5 provides for arbitration. Stop. Clause 17.1.2 provides for jurisdiction of the court for entertaining all the disputes between the parties. Stop. It has been mentioned as Agra/Allahabad. Stop. The venue of arbitration has been provided under clause 17.2.8 to be at Lucknow. Stop para. From the aforesaid clauses, it is evident that for all routine disputes, the clause 17.1.2 may be relevant. Stop. However, for arbitration point of view, the seat being at Lucknow, the proceedings will be at Lucknow. Stop. Even if the proceedings could be at Allahabad, in fact the dispute falls within the jurisdiction of Allahabad High Court, hence it can be at either of the places. Stop. In support of his argument, reliance is placed on Brahmani River Pellets Limited versus Kamachi Industries Limited under bracket 2020 5 SCC 462. Stop para. Referring to the procedures provided in the agreement for resolution of disputes, he submitted that in terms of clause 17.2.3, a permanent dispute resolution body, having equal representation from each of the parties is to be constituted. Stop. The disputes or differences arising under the agreement shall be referred for resolution to this body, which shall communicate its decisions within 30 days, and thereafter the matter is to be considered in terms of clause 17.2.4, which provides that in case of non-settlement of dispute by the permanent dispute resolution body, such dispute or differences shall be referred for decision to a body constituting of MD, DVVNL and head, distribution franchisee under bracket by whatever name called, which shall communicate its decision within a period of 15 days. Stop. Primarily, there are three disputes, semicolon, 1 regulatory surcharge, 2 electricity duty, and 3 tariff indexation ratio. Stop para. Wide letter dated October 21, 2020, the applicant requested for constitution of permanent dispute resolution body for resolution of the dispute, detailed as that applicant is making payment of regulatory surcharge to DVVNL as per TIRN mechanism, but DVVNL is asking for full payment of regulatory surcharge recovered by the applicant. Stop. However, no response was received. Stop. On October 28, 2020, a committee constituted by MD considered the issues. Stop. However, no resolution could be passed. Stop. All the three issues were discussed in the aforesaid meeting. Stop. Hence, to state that the applicant has not exhausted the remedies available in the agreement for resolution of dispute before invoking the jurisdiction of the court is not made out. Stop para. To put the records straight, Mr. Mathur, learned senior counsel, appearing for the applicant, submitted that an application was filed under Section 9 of the Act for interim relief before the Commercial Court, Lucknow. Stop. Status quo was granted on March 16, 2021. Stop. Para. The respondent challenged the aforesaid order dated March 16, 2021 passed by Commercial Court, Lucknow by filing FAFO number 335 of 2021 at Allahabad, which is still pending. Stop. The issue of jurisdiction is also under consideration. Stop. in terms of the interim order dated July 13, 2021 passed in the aforesaid appeal, again the efforts were made for settlement of the dispute stop. However, no positive result could be there stop. Para. Meanwhile, on May 31, 2021, the applicant issued notice seeking appointment of an arbitrator, to which reply was received refusing to appoint arbitrator, raising preliminary objection that the applicant had not exhausted the remedies as provided under the agreement stop. Huge claim was sought to be made by the respondent against the applicant, deposit thereof was sought before consideration of request of the applicant for appointment of arbitrator stop. Clause 17.2.12 of the agreement provides that both the parties shall continue to perform their respective obligations during the currency of the dispute settlement procedure stop. Deposit of money is not a precondition for appointment of an arbitrator for resolution of any dispute stop. Reliance was placed on judgment of Supreme Court in Duro Falguria versus Gangavaram Port Limited 2017 9 SCC 729 to submit that only the arbitration clause is to be seen stop. He further referred to the judgment of Supreme Court in Merces ICOM Tele Limited versus Punjab State Water Supply and Sewerage Board under bracket 2019 4 SCC 401 to submit that even a clause contained in the agreement providing for pre-deposit of certain amount for invoking arbitration proceedings was held to be bad stop. In the case in hand, there is no such clause stop. The respondent just want to add words in the clauses in the agreement, which is not permissible stop. Para. On the other hand, learned counsel for the respondent submitted that the jurisdiction for invoking the arbitration clause is well defined in the agreement stop. Clause 17.1.2 clearly provides the jurisdiction of the court at Agra and Allahabad stop. The district court at Agra will have jurisdiction for the dispute for which the jurisdiction of district court is to be invoked, and the correspondingly the high court at Allahabad will have jurisdiction stop, merely because in the agreement venue of arbitration has been given at Lucknow, it will not confer jurisdiction to the court at Lucknow for filing application under section 11 under bracket 6 of the act stop. In fact, the applicant had wrongly invoked jurisdiction of commercial court at Lucknow while filing the application under section 9 of the act stop. While referring to clause 17.2.12, it was submitted that it is agreed between the parties that both the parties shall continue to perform their respective obligations during the conduct of the dispute settlement procedures stop.